Welcome, fighters. Episode 22 of the Gloves Off podcast. Everyone wants to know what the hell has been going on at Johnson Law since January of 2022. And the answer is we've been working our asses off, y'all. We appreciate your patience. Today's episode, Governmental Immunity, Protecting the Guilty. With me today is the brain trust of Johnson Law. I got my partner, Tom Waun, who runs our Flint office. I got my partner, Paul Doherty, who is the managing attorney in Detroit, and our chief appellate lawyer, Chris Desmond. Just give a real brief overview of what it means to be an appellate lawyer and what that process is.
So my primary responsibility at Johnson Law is to handle things after they move outside of the trial court. So we have to go up to a higher court to try to undo the mistake that occurred below. So that's what I generally work on.
Here's what we're talking about today. A lot of you have heard me moan and bitch about governmental immunity. And I thought, what a great way for everybody to kind of understand what it means than to hear the four of us, since between us, we probably have well over 100 years of legal experience and a lot of white hair. That's not you, Chris. Not quite yet.
It's coming.
But
I see a few sprinkled in.
Just a few. All right. So Tommy, first time when you were involved with governmental immunity back in the early 80s?
Yep, probably the late 80s.
Okay. So tell me, did you even know that there was this thing called governmental immunity when you kind of went into your first law job?
I did not. Not until we got about 3 or 4 years into it. We were defending, I was with a defense firm that was defending the city of Detroit. We were defending Wayne County. And then we got to understand these extra protections, these walls you could put up in front of people who were hurt and prevent them from recovering anything.
Paul, did you know when you first got into practice doing personal injury that there was a thing called governmental immunity?
No, you don't know about it till it gets slapped in your face, pretty much.
Right.
When you've not done the 15 things you were supposed to do to get yourself possibly in a position to sue the government. That's usually when you learn it, when they tell you what you haven't done.
Well, much like Tom, I started at a defense firm at what was then Cole Seacrest, and I had no clue there was governmental immunity. And then all of a sudden, we were representing Tommy. I'll never forget this because this is one of the reasons I ultimately became a plaintiff lawyer. We represented a school bus driver from Howell and the Howell Intermediate School District in a case where the school bus ran over a young boy and killed him, obviously. And his dad came to the scene to find out why his kid wasn't home and saw his son in the middle of the road. And I learned as a defense attorney at that time, there was a thing called governmental immunity. And unlike what's going on today, and we'll certainly get there, guys, I promise. When I first learned of this, and I went to John Seacrest, who's kind of a guru, great defense lawyer, it was like, what does it mean that the bus driver, you have to prove gross negligence as to him, and yet we only have to prove negligence as it relates to the school district? And for a lot of folks, and John was like, don't worry about it. They mean basically the same thing. And so I just think it's really interesting for at least 3 of us old guys here. Don't you find it interesting, guys, that back then it was in place, it had been up and running, but it really wasn't a big deal. How do we explain that? Why wasn't it?
Well, I start with the name John Engler.
Amen, brother.
Yeah, I start with John Engler. When he appointed 4 justices to the Supreme Court.
Former governor of Michigan for, by the way, 3 terms, 12 years. Last time we had a 3-term governor, and we changed the law to make it only 2. I wonder why. For 8 years. Go.
Thank goodness. When John Engler appointed Cliff Taylor, Bob Young, Maura Corrigan was elected, and Steve Markman, and then they became a majority on our Supreme Court. They took what had been a diluted law and they turned it on its head. They changed it and they made it very strict in favor of the government to try to prevent people from recovering money.
Right. Paul, do you remember when I call them a gang of 4. I don't know what you call it. That's the only terms I'll use even on a podcast right now. But do you remember when that happened?
Oh yeah, because they were the first group of justices to whom precedent didn't mean a whole lot. And they were rewriting cases that had existed for 20, 30, 40 years that slightly favored the plaintiff, and they would just disregard that and say, here's our ability, our authority to now rewrite those rules. Now, and also in fairness to a lot of the system, the 80s isn't that far removed from the 40s and 50s in legal parlance. You're talking about an era where people didn't have a lot of rights, or the rights weren't recognized. So you had these kind of personal injury pioneers in the 50s and 60s Mel Belli out in California. You can, spot guys around the country.
Harry Philo here,
Philo, Zeff,
Bob Zeff,
Charfus.
Right.
These are those guys that were sort of pioneering the plaintiff world. And by the 80s, we were all catching up with that.
But Chris, Paul mentioned the word precedent, case law precedent. And I'm going to ask you about stare decisis, what that means. And now we're just a few months after the overturning of Roe versus Wade. That's similar to what we're talking about right now. Explain that a little bit about what stare decisis means.
Stare decisis essentially means that courts look to have stability in systems. And so they want litigants and the public to be able to understand what the law is and what their rights are. And so when a decision comes down, unless there is significant reason to believe that decision was wrong, they're very apprehensive about overturning that decision. They like the law to remain the same. It's interesting to hear you guys talking about how governmental immunity wasn't as big of a deal for you when you started your careers. By the time I started mine, so in 2007, it was already sort of the monster that it is today, right? Because, and a lot of that is because of that disregard of stare decisis. There was a major decision that came out from the Supreme Court in 2000, that from the Gang of Four, as you would refer to them as, that really significantly changed the protections that were given to the government.
So Roe versus Wade, the fact that it had been in the law of the land for 50 years, is it from an appellate lawyer standpoint, is it a big deal that the new composition of the United States Supreme Court completely went the other way and said no longer is it a federal right?
It's a gigantic deal, and I think you can see how gigantic of a deal it is by looking back at the confirmation hearings of the justices that were involved in that decision, right? Because they were all asked, "What's your view on Roe? What's your view on stare decisis?" And the response was overwhelmingly, this is the law of the land. It's established law. We respect precedent. We won't overturn it. That's a settled question.
Okay.
And so the fact that that's what everyone was focused on, shows how important this issue was to people. But what it really does is, unfortunately, it calls into question all of the rights that we think we have with this version of the Supreme Court.
So here's my question. Tommy and Paul and I are talking about stare decisis and how it wasn't a big deal really in the early to mid 80s. And now we get into the early 90s, more toward the mid 90s. And the Gang of Four, the new Engler appointees on the Michigan Supreme Court, do exactly what the United States Supreme Court did in Roe, only on governmental immunity issues. They took cases that had been in effect for 30, 40 years sometime and completely said, oh, those guys were wrong. We're right. We're now going 180 degrees in the opposite direction, and you can't sue the government. Is that fair, Chris?
No, it's not fair. And it's also, it's hypocritical as well, too, because what's happened since then is they throw out stare decisis with some of these major decisions in the early 2000s, late 90s. And now they prop up those same decisions by saying, well, that's stare decisis, so we can't do anything about it anymore.
Right.
So they were okay with throwing out precedent before, but now that they have the case law in place that they agree with.
I have a perfect example of a case, my very first case involving governmental immunity and the exceptions to governmental immunity. I represented a kid on a motorcycle, and he's on a country road coming up a hill to an intersection. The stop sign coming into the intersection from the other direction, the people who were going to cross the road, had been knocked down, and it hadn't been put back up by the County Road Commission. And they knew it was down, and they just took their time doing it because they had other things to do. This guy drives right through the intersection because there's no stop sign. He hits my motorcyclist. The guy has a brain injury, and he can't work for the rest of his life. Now, clearly, when in that time period, there's a governmental immunity exception in the statute that says maintenance of a roadway is something that the government has to do, and if they don't do it appropriately, you can be sued for that.
Right.
Under the old law, that included signs. It included
traffic signals.
It included putting up barriers on the side of roadways.
It included design of the actual roadway.
Yep. If it wasn't banked well enough on a curb, all those kinds of things. And it made sense because the government's taking care of the roads. The roads include the signage system. And my client recovered a lot of money, and he has a structured settlement that's going to protect him for the rest of his life. God bless that.
Because to be fair, Tommy, the road commission screwed up.
Oh, there's no question the road commission screwed up. There's absolutely no question about that. And I'll call it the Engler court. It was a Cliff Taylor court. They modified governmental immunity. They found an existing case to be not good law anymore, and they overturned it. And now the only time you can sue under the road maintenance statute is if you have a defect in the roadway itself, not on the shoulder, not anywhere, none of the signs, none of that.
Wait a minute. So the stop sign that was knocked down, that's not in the roadway.
Right. That's not part of the roadways.
So the new law that they completely changed and went the opposite way, just like Roe versus Wade on the United States Supreme Court, the Michigan Supreme Court says it's not in the roadway. That makes no fucking sense at all.
Well, it makes no sense. And when you think about it, if you asked any person on the street, and I think we all have an idea of what's right and what's wrong, what's fair and what's unfair. If the government has a responsibility to maintain roads, and if a stop sign gets knocked down, and they know it's knocked down, and they don't put it up, and somebody dies as a result or has a serious injury as a result, anybody looks at that and says, well, that's not fair. The government should have to pay. That's their responsibility. Well, not with our current interpretation of governmental immunity.
So, Chris, we're going to talk in a minute about what governmental immunity is and the exceptions, but under Tommy's case, if you will, in today's court, since the stop sign is not in the actual roadway, I would freaking hope not, right? Because you're going to have to run down the stop sign too, right? There would be no case.
No, there's no case. And it's swung so much farther than that now. So that's been established law for a while. Traffic signals, that's not part of the roadway.
So, but traffic signals. So in other words, a county road commission, guys, or even a city, can have green lights going in both directions and have a 90-degree side impact, and there's no liability because it's not the roadway.
Against the government.
I mean, that's fucking insane.
And so now it's to the point where it's not just the surface of the roadway, it's the surface of the roadway that's intended for vehicular travel.
What does that mean?
Is what the law says. So to give you an example of how it plays out, we have a case a couple of years ago. Our client is walking on Michigan Avenue in Detroit during the St. Patrick's Day parade, and there's a bolt sticking out of the old brick road that they have there, right? She stumbles over the bolt, falls, gets seriously injured. The bolt was in what's technically a parallel parking lane, because you know how you can park on the right-hand side of many streets in Detroit. They said because that's not where cars are supposed to drive, the city doesn't have a responsibility for maintaining that part of the road.
Don't you have to drive to get into a parking spot?
You do. But that's not the primary purpose of that part of the road. So that's how far
who would drive over a bolt? I mean, come on. That's not.
But to me, again, Tommy talked about a sense of fairness and right and wrong. If it's their job, which it is, to take care of that so that no one gets injured, they should have to pay for it, but they don't.
They don't.
All right, Paul, in terms of this switch over, if you will, when you first got involved and saw the Engler court, tell us, our listeners, what do you remember, like one of the biggest, most vivid examples for you about how this has gone absolutely off the tracks and gone the opposite way?
It was across the board, it felt like. You know, when you're reading a published decision from the Michigan Supreme Court, and they're explaining to you why they don't have to follow what had been the law of the land 30, 40, 50 years,
right.
It made no sense. It didn't make sense as a lawyer. It wouldn't make sense to a law student. So they were overturning things and supposedly rationalizing why they didn't have to follow precedent. Anytime they had a chance to narrow the scope of the exception, they did it. But within those exceptions, they then started defining those in a very limited way. In other words, a roadway defect. Let's just make the road narrower and narrower and narrower. Okay,
so you can't bring a case.
So you can't bring a case,
right?
Because like the actual tire tracks were fine, but 1 foot outside the tire tracks are not fine. Right. So you can't do it. And and there's just really examples of every area. Setting aside the hurdles you have to get through to get the case into the courthouse, just do you have the facts that fit within how they've narrowly defined it? And I just remember being struck by the language of these opinions.
Right.
Conservative, liberal, whatever. It doesn't. It's intellectually bankrupt, intellectually dishonest to rationalize a change of precedent.
Going 180 degrees the opposite way.
Yeah, because you don't like the existing precedent.
Well, but now this is where you got to talk about politics. Sorry, guys. Right? Seriously. When Engler came in and did this.
And he was unabashed.
He did it on purpose. And by the way, he was a lawyer. His wife, Janet, then Fox, was a not only plaintiff personal injury lawyer from Texas, but she was a med-mal birth trauma lawyer, guys. So what the fuck he had against lawyers in the legal profession. But what we all knew was going on and what we ultimately heard, and this ultimately started with Engler in our state and then went to President Baby Bush, as I call him, That's a whole nother episode we could talk about, right? How the damn trial lawyers, you guys remember about that? And I literally had to talk about our president bashing the very thing that I am in front of juries while I was picking
They
a
made
jury.
it a bad word.
They did.
An evil word. You're a trial.
Right.
Look at what the Michigan Trial Lawyers Association did.
I know, it makes me sick. But
They
we
changed their
it.
name.
I know.
Michigan Association of Justice.
For justice.
It's like, why are you guys running from who we are?
Well,
That's a different story.
That isn't, but it's actually a similar story. But the fact of the matter is because of the politics, who was the number one campaign donators, if you will, to the Democratic Party? And we had at the time, it was the unions. Well, how are we doing with them now since they've been dismantled? Number one was the AFL-CIO and the related trades unions. Number two was the MEA, the Michigan Educational Association. And number three at the time was because the teachers and the other unions often kind of pooled their money, and trial lawyers were the third. So it's not any fucking clue of what was really going on, but no one really thought it was going to last, right? Because I remember, Tommy, when some of these opinions first came down, and it was when I was a defense lawyer and I had that case I told you about, the school bus case, I thought it was incredibly unfair, right? That the driver who ran over this 5-year-old, the boy was in front of the bus, you guys, he got run over by the front wheels. I mean, the bus was stopped when he got off the bus, right? So there's no question he was negligent. But one of the arguments was, and we settled during trial, I might add, one of the arguments was, of course he was negligent, but he just wasn't gross negligent. And I remember Seacrest, because we talked about this. John had never argued that before, and he at the time was probably a 30-some-year lawyer, Tommy. So when we talk about how it wasn't a big deal before, here's a guy that represented and just never even argued it before because he really didn't think it was that big of a deal. And then the other one that and Chris, I guess we should go into this a little bit right now. Governmental immunity basically means you can't sue us unless we say you can, right?
That's right, yeah.
And then now I always say is, and then when we say you can, we really don't mean it anymore.
Yeah.
All right. So what that means is in a tort case, which is what obviously Johnson law does, that means you can't sue, in this case, let's talk about my Howell case. You can't sue the Howell Intermediate School District and the driver, and by the way, I remember his name very distinctly, sadly, and the little boy, I'll never forget his face, I'll never forget his name. But the fact of the matter is, you can't sue them except for the ways that we're going to talk about right now. Tell us a little bit about what that means.
So when you're dealing with a governmental defendant, whether it's an individual employee or whether it's an entity, meaning a
State of
city,
Michigan,
a municipality,
County of Waun employee,
right,
Oxford Community School teacher,
or a department of the state, the Department of Transportation, for example, anything along those lines, you need to have an exception, and these are things that are located in a statute. It's called the Governmental Tort Liability Act. You need to have an exception that specifically allows you to sue that defendant.
Okay.
So
in other words, you can't do it unless it's one of the 5 exceptions.
that's right. And
so I don't think people get that, guys. Think about this. The Michigan law is you can't sue the people who you put in power, and you pay through your taxes, our taxes, you pay their salaries, you can't sue them. Number one, that's where I stop right there. That's unfair. You're elevating somebody's status or not. And what if they just said all white people? You can't sue white people from now on. Everyone would go, what the fuck are you talking about? We're beyond that. Well, are we? Number one.
Well, look where it started too. In basically English common law, the king could do no wrong.
that's exactly right.
That's where it started. You
Right.
can't sue the king.
Right.
And imagine that makes its way over here to now modern day government. That's
one of the reasons why we came here and started. But Tom, you have a different perspective. Say, do you think it's fair? Just the one we're talking about right now. You can't sue.
There has to be a line somewhere. It's just a matter of where you draw the line.
Right.
Intentional infliction of emotional distress is a tort.
Right.
Okay. My next door neighbor is so loud that they're making it so I can't sleep at night, and I call the cops, and it's their job to tell them to stop, and they don't do it, so I want to sue the cop too. Okay. To me, I have a problem with that. And so there's somewhere to draw the line. But
I hear you.
Yeah, so anyways.
No, but it's a very important perspective. So even though you're completely wrong, I appreciate
it. Which means that it's not a perspective.
You knew we were going there, too. It was just, I waited almost a half hour before I said it. All right. But anyway, Chris, so you can't sue the government at all unless we fit in the exceptions. And tell the folks, generally speaking, we're not going to get hopefully too technical, but what are the major exceptions exceptions
Well,
that our cases involve?
So first of all, you have to break it down between exceptions. There are exceptions that apply to entities and exceptions that apply to individuals.
So
And
what's
just
an entity?
An entity is a city, is a department of the state,
State
is
of
something
Michigan,
along those lines. And the reason why this is so important, I think, in a normal case that we have, if we sue Jimmy John's, for example, Tom had a very successful case against Jimmy John's. When we sue Jimmy John's, we're able to sue the individual employees
And the
for their
corporation,
negligence,
right.
and then the corporation is liable for their negligence, even if the corporation, the employer, knew nothing about what was happening. It's called vicarious liability, and it's a way to ensure that people are responsible for the negligence of their agents. Well, with governmental immunity, it doesn't work that way. If a governmental employee does something negligent to harm one of our clients, we can't sue the employer under that same theory, unless there's an exception that applies to the employer too. So the exceptions that apply to the entities, the major ones that we deal with, there's a highway exception, which we already talked about. Similarly, there's a sidewalk exception, which is very similar to the highway exception. If there's a defect in the sidewalk, and they get specific. They say if it's a 2-inch defect,
Well,
if it's
now doubled. Remember, it was an inch, and then too many municipalities. What folks don't maybe realize, and they hear about injuries, especially trip fall injuries, and they become very, very skeptical because of what I'm going to call the just obliteration and the one-sided reporting nature. But how many times in my career, guys, that I've had, especially elderly, but young kids and elderly, severely injured by a defect in a sidewalk that they simply didn't appreciate while they were riding their bike, walking down the street or whatever. When most people don't know, the municipality, before all this nonsense that we're talking about, had an absolute obligation to fix it, right?
Right.
And then it started at 1 inch, didn't it?
Started at 1 inch, I think, and then it went
One
to 2
inch and a
inch,
half, or
and then they amended again to add in the open and obvious doctrine to the sidewalk exception.
So if it's over 2, it's open. And
If it's
obvious.
over 2,
if it's
it
under
becomes-
2,
That's
there's
right.
no liability.
translation, you're fucked either way.
Yeah.
Welcome to Michigan.
That's one of the best rules around, right there. It's insane. In other words, they write into the law a way you cannot recover.
And this is my point. If the people that we put into power are insulated from liability when they fuck up, what are we doing? That's why I call protecting the guilty.
Well, and part of what we're doing is we're shifting economic burdens, right?
Oh no, here comes law school.
Because really,
I think I was asleep
one
that
of
day
the-
at UAD, guys. I don't know about you two.
One of the policy
Was it 1 day,
arguments
or-
in favor of governmental immunity, they talk about how, well, this is going to cost governments too much money if we do this. Well, when
Who pays
someone
for
gets
that?
seriously injured, if the government's not paying for it, it's just going to the rest of us in some other way.
Amen. That's
Through
exactly what it
insurance,
is.
through Social Security disability, through whatever it is, that money is going to be paid to that person from someone.
Right.
It's
Medicaid,
just,
Medicare.
should it be the person who actually inflicted the injury upon them?
Right.
Or should it be the public as a whole?
All right. So you talked a little bit about the entity exceptions. Now let's talk about the individual. Because, I can't help myself, gross negligence, these proximate cause. So I told you about the school bus driver, and I learned as part of that defense, and as I told you, I actually taught John Seacrest, who certainly didn't mean to teach him. He was a brilliant lawyer, but he didn't even freaking really know about the gross negligence, what it meant. What is it? Is that a big deal, Chris, now? Is that in terms of proving that an individual like the school bus driver, instead of just proving negligence, I now have to prove gross negligence? What's that mean?
So gross negligence, there are sort of two parts of this gross negligence exception. And I know we'll focus on the other one later, the proximate cause
Yep.
requirement, because that's a disaster in Michigan law. But the gross negligence requirement, really what it does is it puts you and the plaintiff, I think, you're very judge dependent in that moment when you've got to
Meaning?
show gross negligence.
Meaning?
Well, how do you tell the difference between negligence and gross negligence?
It's a
not
matter of degree.
Right. There's not a great legal definition of it. It's not one of those things where
What is the legal definition?
So it's showing reckless disregard
As to whether an injury will
whether
result.
an injury will result.
What's
So
that?
with gross negligence, what they do is they kind of try to compare it to other standards. So they say it's not quite intentionality and it's not quite recklessness, but it's not just negligence. It's somewhere in between there.
Isn't that what juries get paid a whopping $15 a day in Michigan to decide?
If they're given the opportunity,
And so
which
what
they're usually not.
And what we all know happens now in gross negligence, guys, and why Chris kept talking about it depends, judge dependent, because overwhelmingly, I'll bet you, if I had to bet, and I don't bet, other than on our cases, right, every day. I'll bet you 75% or more of gross negligence cases brought in Michigan against an individual, and I'm going to, like the teachers at Oxford Community Schools, part of the shooting, it's a gross negligence case. Those cases get thrown out of court by a judge, never go to a jury. How can that be?
Just 75%? I bet it's.
It's higher.
It's
You think
more
it's
than
higher?
that.
think
For
it's
gross
higher.
negligence
I bet
claims.
it's
No
90.
question higher. No
I bet it's
question.
90.
But we let almost every case, when some person gets charged with a crime, right, even though that burden of proof is beyond a reasonable doubt, it's almost impossible once they charge you with a crime to get it thrown out of court before trial. Why do we then, when it comes to, then that's with someone going to jail. Then how on a civil case, when we're talking about, quote, only money, I don't think that's all we're talking about because it's justice, but only money, how do we then make it impossible on the victim to bring a case?
Well, and we also, and this is not to get kind of too nerdy about it, but we encourage governmental defendants to bring those motions. We call them motions for summary disposition.
Early.
Where they argue to a court, we shouldn't be on the hook. The court rules encourage governmental defendants to do that because it gives them an automatic right to go to the Court of Appeals if they lose that
Now
motion.
you're going to tell them about the rocket docket.
Yeah, and so in a normal case, you don't get to appeal until the case is done, until you have a
After
final
a trial
order in the case.
Or judge throws a case out, but mostly
That's right.
they wouldn't. They would go to trial and you would either win or lose, and then what?
So in governmental immunity cases, you've got this exception, which Ven calls the rocket docket, where the court rules say that if your motion for summary disposition is denied and you're a governmental defendant, you get to automatically go to the Court of Appeals. Well, the reason why that's such a big deal is because that's not a fast process. Most of our appeals, just in the Court of Appeals, take 16 months, and that's if we don't go up to the Michigan Supreme Court after that and spend another year there. So now you have catastrophically injured clients who need money in order to start to, recover and heal. They're told you have to wait 2.5 years before we even get to go to a jury, and then they might appeal again. So, some of our governmental immunity cases that have really gone the full distance, like the Kirsch raid case, that was a 7.5-year case. Kirsch was 13 by the time he got injured. He was 21 when we settled that case.
On the week before trial.
Yeah, and so you have to have clients who are willing to stand by you that whole time, right? Because governmental defendants could come in and they can lowball you and say, settle now for a lower sum.
Two things in Kirsch. In the next episode, we're going to finish up here, and then we're going to talk about individual cases that we've all had. Kirsch, luckily, had Michigan auto no-fault law to his benefit at that time, which back then guaranteed that he had benefits for the rest of his life. And his parents, lucky for Kirsch's mom, you remember Jackie.
Mm-hmm.
She was amazing, still is amazing. Jackie had a job and had amazing insurance. So whatever auto didn't pick up, her insurance did. And then we all know not everybody is that fortunate. So he could afford to wait 7.5 years, and I put that in air quotes. But
Chris, isn't the right to an automatic appeal something written in the court rules as opposed to the statutes?
It is. It's right. Yeah, it's
Yeah,
the court
and-
rules. So
and
that's
so that's
Wasn't
Supreme
that written
Court.
by the same
Supreme
gang of
Court,
four
that's
Supreme
right.
Courts
Great point, Tom.
that automatically gave these governmental entities a right to have the Court of Appeals
Yep,
review what the
that's
trial court
exactly
does
right.
and give the government different rights that other people don't have?
Yeah.
And so perhaps our Supreme Court could be asked to take a closer look at that and decide if that's a good idea anymore.
Yeah.
It's just not fair. If the average citizen does not get an automatic right of appeal when a judge throws their case out or before whatever, right?
Mm-hmm.
Then they absolutely should not. The government should, in my opinion, should not have an elevated ability, if you will, to screw over. All right, we're going to wrap up, guys. Episode 22, Governmental Immunity, Protecting the Guilty. But tune in to episode 23 because we're going to get into a bunch of different cases that not just Johnson Law, but Tommy, and we call it Previous Life. We talk about other firms and so forth that we work with. Give you guys a living, breathing examples of what I'm going to call my interpretation, how evil when governmental immunity with a gang of four and the Engler appointees, how out of control it got. And here's a little bit of a silver lining. Thanks to Mr. Desmond and our firm, we chipped away at that recently and got a really great opinion in the Ray versus Swagger case that Chris just mentioned. It was the first time the Michigan Supreme Court ruled in favor of a plaintiff, an injury plaintiff, since
84 was the
Was it?
last time that a plaintiff had won a gross negligence case there. Yeah.
So we're going to tell you all about that. Thanks for tuning in, Fighters. This is signing off for episode 22. Talk to you in a next episode. More to come on governmental immunity protecting the guilty. Give them hell, fighters.